Hello, my name is Bryce, and I have a degree in political science, a minor in philosophy. I'm a former provincial candidate, and I want to say thank you to Renee for giving me the opportunity to be able to share my knowledge. My degree, I have a dual emphasis in Canadian studies and international politics, and I will be utilizing in this video my knowledge of the Canadian Constitution to talk about Section 35 and the subsequent court cases that expanded treaty and Indigenous rights within Canada. This is a personal gift from Renee to her community because she recognizes, like me, that knowledge is power. And the best way to defend yourself is to know your rights. So, what is Section 35 of the Canadian Constitution? It recognizes and affirms treaty and Indigenous rights, recognizes and affirms pre existing rights. It's pretty ambiguous and vague, right? And that's the problem with constitutions a lot of the time is the language is pretty vague and it can mean a lot of different things. And so we need jurisprudence, which is basically court cases via the Supreme Court to actually figure out what that means in constitutional law within Canada. So a little bit of background on Section 35 of the Constitution is that it almost did not exist. It was a controversial inclusion. During the 1981 patriation negotiations under Peter Elliott Trudeau, Indigenous rights were actually dropped from the negotiations entirely. Indigenous leaders and activists fought really hard to ensure that they would actually be included and get them back. A specific term in the Constitution existing was a compromise to actually assuage the provinces because they were concerned that if they didn't have pre-existing rights, that it would maybe expand and be too broad for the protections of Indigenous peoples within Canada. But because of the persistence of Indigenous activists in the subsequent decades and legal challenges, those words have grown to really mean something within Canadian constitutional law and still are very binding, broad, and protect pre-existing Indigenous rights that even pre-exist the Canadian Confederation. Section 35 is actually located within the Constitution Act, but is not located in the Charter. The Charter is in Part 1 of the Constitution Act, and then Section 35 is in Part 2 of the Constitution Act. This is actually a good thing because it means that it's actually outside of the areas where it would maybe be able to be overridden by the notwithstanding clause, and that would be disastrous if that was the case. So whoever designed it this way was very smart. Notwithstanding clause can only be used for sections 2 and sections 7 to 15 within the Charter. It can't be used as a broad-based way to override any rights within the Charter or the Constitution. One thing that is a little bit confused and people misinterpret that this was not granting rights to Indigenous people, that these were rights that were already held because they had pre-existed the Confederation. Prior to 1982, they were actually recognized as a right, but they were common law and they were not constitutionally protected, which means that they weren't as robustly protected by Canadian law. Within the inclusion of Section 35, it actually upgraded them to constitutional protections, meaning that there's a lot more bite and strength to them, meaning the courts have to take them seriously because they're part of the foundational law that makes up Canada. So a foundational case was the Queen versus Sparrow. This is in 1990 when the ruling was made. It began the trajectory of our Section 35 really began to have teeth, and courts started expanding what Section 35 meant within the Constitution. The case was Ronald Sparrow of the Musqueam Band in BC was charged for using a fishing net that was larger than regulations for his band, charged under the Fisheries Act. He challenged it in court and said that this was an inherent right, that he could not be bound by regulation because this was an inherent right that his band and his people had, and it was protected by Section 35 under pre-existing rights. Ultimately, when it got to the Supreme Court, they agreed. They said that at the time, Aboriginal or Indigenous rights were inherent. They were not a gift from the Crown. They pre-existed the Canadian Confederation and were held for millennia by the First Nations of Canada. They don't need a treaty to have the rights. It's protected by Section 35 of the Canadian Constitution. As many of you know, probably a lot of BC territory is unceded land and is not covered by treaty. In this particular case, the Supreme Court develops a test they called the Sparrow test. Step 1 is obviously trying to figure out, is there an infringement being done on a pre-existing right? In step 1, you ask questions, is the law unreasonable? Does it cause undue hardship? Does it deny the holder of said right their preferred method of exercising said right? Step 2 is it justified? In step 2, whether or not it's justified, you need a valid legislative objective and is acting consistent with the fiduciary duty, which is something else the Sparrow case created. So the fiduciary duty is based on the concept of the honor of the Crown, premised on the fact that there's a power asymmetry between the Crown and the institutions of the Canadian state and First Nations people. And because of this, the Crown is obligated to act fairly and in the interest of First Nations people, and that creates the fiduciary duty. At the time, they described the relationship between First Nations or Indigenous people within Canada and the Crown as trust-like, not adversarial. The Crown has obligations that flow from that trust, and the Crown and governments cannot regulate these rights out of existence. And this is the beginning of Section 35 turning a mission statement within the Constitution into legal obligation. And not just any legal obligation, but constitutional. And this was the whispers of a beginning of the consultation process, because now governments in Canada, whether federal or provincial, had to justify infringements upon any Indigenous people within Canada. This was the spark that ignited everything that would subsequently follow in the decades to come. But unfortunately, the courts don't always get it right. For example, there's a very controversial case in 1996 called Vanderpeet versus the Queen. And this was when an Indigenous woman of a BC band was charged for selling sockeye salmon under just a food license, but she didn't have like a commercial license. She tried to argue that this was an inherent right based on the ability to trade. This is when they started to create guidelines and a test around what made an inherent or distinct right for an Indigenous group. And this is why it's really controversial, because they made it that it had to be distinct and prior to European settlement in Canada. Meaning that even though prior to this, they had already said that rights weren't frozen prior to 1982, but they now are contradicting themselves that the rights froze earlier than 1982. And many legal scholars today critique it. But I do think that because Canada operates on something called living tree constitutionalism, which is a legal doctrine that presupposes that society is constantly growing and ever changing, and so too does how we interpret our constitution need to grow and change to match the values of modern society. Though Vanderpeet was incorrectly cited in 1996, that precedent could be overturned in subsequent rulings down the line. Also in that same year was a very foundational case called Badger versus the Queen. This case was 3 Cree men were found hunting in private land in Alberta. They were charged under the Provincial Wildlife Act for hunting out of season and without a hunting permit. But they held treaty rights signed in 1899 under Treaty 8, which guaranteed the right to hunt for food. The Crown tried to argue that the NRTA, or the Natural Resources Transfer Agreement, extinguished those rights in 1930. But the court did not agree. They said that the NRTA extinguished commercial hunting rights, but did not extinguish the right to hunt and subsist, so they ruled that Treaty 8 hunting rights survive and are still protected. But the real legacy of Badger are the 2 interpretive principles that were established during this majority opinion. First was that any ambiguity in the treaties had to be resolved in favor of First Nations people. The second was treaties must maintain the integrity and honor the Crown's fiduciary duty to First Nations and Indigenous people. To do this, the treaties must be interpreted as they would have been interpreted by First Nations people at the time they were signed. And the fact that they ruled this was actually implicitly massive, because this meant that oral histories were going to be listened to in court and were going to have evidentiary weight. This is because the written text is the Crown's version, but First Nations people at that time were operating in completely different frameworks: cultural, legal, and linguistic. There were multiple translators because there were several languages, sometimes translators for translators for translators. It was complicated. And because of this, many signatories could not read what was being put in front of them. The text alone basically tells you what the Crown thought, wanted, or claimed. The ambiguity that Badger is actually resolving, though, is not ambiguity necessarily in the text itself. The ambiguity between the interpretations of the signees and the bands that signed onto these treaties and the Crown. Massive gap between the 2 fundamentally different interpretations of what those treaties meant. First Nations communities today are still saying this is not what we agreed to. The cede and surrender was not a thing that we agreed to or even had as a concept, and the court honors that. The only surviving record of what First Nations agreed to at this time is oral histories giving them evidentiary weight within the courts, or at least the beginnings of it. This is why I believe Badger set up the ruling for Delgamuukw, which is foundational and would be decided a year later. Badger sets up the volley, Delgamuukw spikes it. And I'll cover that in part 2.